Friends, today let us deal with the right to equality. The individual rights and freedoms, and also the relationship between the individual on one hand and the state or the society on the other, is and has been a continuing, unsettled and open-ended problem since a time immemorial. It is apparent that it comprises the rights that the state gives to the individual. There can be genuine individual freedom only when the individual is free from exploitation and from economic and political oppression. Some written constitutions, like the Indian Constitution, guarantee a few rights to the people and forbid the government organs from interfering with the same, and the chapter on fundamental right expresses the concept of inviolable and basic rights of the people of India. In the international sphere, the concept of equality is proclaimed in the Charter of Human Rights, called the Universal Declaration of Human Rights, 1948. It is declared in the Article 1 of the Charter as, all human beings are born free and equal in dignity and rights. The Constitution of India also declared the right to equality by taking care of the reality of varying needs of the different classes or sections of people that will require differential and separate treatment. Articles 14 to 18 may be grouped together under right to equality. Article 14 provides the general principle of equality before law. Article 15 provides no discrimination on the ground of religion, race, caste, sex and place of birth. Article 16 provides for equality of the opportunity in the matters of public appointment. Article 17 provides for the Act of Untouchability abolished, and Article 18 provides for abolition of the titles. The Article 14 is the most important and been subjected to judicial interpretation time and again by the judiciary. The article embodied the general principles of equality, and the articles 15 to 18 are specific aspects of equality. Articles 14 to 18 taken together enshrine the principles of equality in absence of discrimination. And among these provisions granting equality, some aspects of equality are extended to all persons, whether citizens or aliens, and some articles are guaranteed to the citizens only. Therefore, it is necessary to analyze the concept of equality as provided in the different articles under Part 3 of the Constitution. The provision goes, no state shall deny to any person within its jurisdiction the equal protection of the laws. The Indian provision of equality provides two concepts, that is, equality before law and equal protection of the laws. This equality before law is a negative concept which implies absence of any special privilege in favor of any individual, and all individuals are subject to the ordinary law. The equal protection of the law carries with it a positive concept. It means like should be treated alike, and among equals, law should be equal and equally administered. This equality before law is akin to the concept of rule of law as enunciated by A.V. Dicey. His enumeration of the rule of law is that no man is above the law of the land, and that every person, whatever be the rank or status, is subject to the ordinary law and amenable to the jurisdiction of the ordinary tribunals. Equal protection of the laws has a positive content. It does not mean that identically same laws should be applied to all persons, and that every law must have universal application within the country, irrespective of the differences of circumstances, and legislature is entitled to make reasonable classification. And by reasonable classification, it means it should not be arbitrary, and it should be based on reasonable differentia, which distinguishes persons or things grouped together, and then those left out of it. And the differentia adopted must have a rational nexus with the objective, so to be achieved by the act. It is not possible to exhaust the circumstances or criteria which may hold good for classification in all cases. Whether a classification adopted by the law is reasonable or not is a matter for the court to decide when a dispute comes up. Firstly, the president or the governor of a state shall not be answerable to any court for exercise and performance of the power and duties of his office, or for any act done or purporting to be done by him in exercise of and performance of those powers and duties. Secondly, no criminal proceedings whatsoever shall be instituted or continued against the president or governor in any court during his term in the office. And thirdly, no civil proceeding in which relief is claimed against the president or the governor of a state shall be instituted during his term of office in any court in respect of any act done by him in his personal capacity, whether before or after he entered upon his office as president or governor, as the case may be, left at the office, stating the nature of the proceeding. While the general principle stated in Article 14 extends to all persons in India, Article 15 refers to a particular aspect of equality. This article is available to citizens only. It prohibits discrimination against any citizen in any matters that may be taken up by the state on the grounds only of religion, race, caste, sex, or place of birth. The scope of this article is very wide. Article 15, clause 1 specifically bars the state from discriminating against any citizen of India on the grounds only of religion, etc. And Article 50, clause 2 prohibits subjection of a citizen to any disability, liability, restriction, or condition on the grounds only of religion, race, caste, sex, and place of birth. With regard to access to shops, public restaurants, hotels, and places of public resort maintained wholly or out of the state fund or dedicated for the use of the general public. Article 15, clause 4 and 15, clause 5 constitute exceptions to the general provisions of no discrimination on the grounds only of religion, race, etc. Under Article 15, clause 3, The state is not prevented from making any special provision for women and children, and the state is not prevented from making any law for advancement of socially and economically backward tribes. The state is also not prevented from making any law for such persons relating to their admission to educational institutions. Article 16, Clause 1 of the Constitution guarantees equality of the opportunity in the matters of public employment and applicable to all citizens. Say, according to Article 16, Clause 2, no citizen would be discriminated against in the matters of public employment or office under the state on the grounds only of religion, race, caste, sex, descent, place of birth or residence. Article 15 and 16 are instances of equality in the specific situations. The only exceptions to the rule of equality in the matters of public employment are residence within the state may be laid down by the parliament as a condition of a particular classes of employment under any state or local authority. The state may reserve any post or appointment in favor of any backward classes of citizens who, in the opinion of the state, are not adequately represented in the services under the state. Officers concerned with a religious institution may be reserved for the members professing particular religion. The claims of the members of the scheduled castes and scheduled tribes to be taken into consideration in the matters of appointment to the services and the posts under the union or states. Article 17 says, untouchability is abolished and its practice in any form is forbidden. The enforcement of any disability arising out of untouchability shall be an offence punishable in accordance with the law. Article 35 of the Constitution authorizes the Parliament to make law to punish this offence of untouchability, and in exercise of this power, the Parliament of India has made the Untouchability Offences Act 1955, which has been amended and renamed in 1975 as Protection of Civil Rights Act 1955. The prohibition of untouchability in the Constitution has been given a fixed and certain shape by this Act. However, the Act has not defined in clear terms about the meaning of the practice of untouchables, but it is well-known practice which looks down upon certain depressed classes solely on account of their birth. Article 18, Clause 1 prohibits the state from conferring any title except a military or academic distinction. And Article 18, Clause 2 prohibits citizens of India to accept title from the foreign government. Title is an expression fixed at the end of the name and an appendage. There has been criticism from the public that during the time of Britishers, conferment of the title was misused by corrupting social life. Therefore, the Constitution seeks to prevent that evil, and it must be clarified that national awards are not titles. In the case of Balaji Raghavan versus Union of India, EIR 1996, Supreme Court 770. This is a celebrated case in this regard. It has been held that the awards Bharat Ratna, Padma Vibhushan and Padma Shri, called the national awards, would not amount to title within the meaning of Article 18, Clause 1, and they should not be used as suffixes or prefixes. If it is done, the defaulter should forfeit the national award conferred on him or her by following the procedure laid down in Regulation 10 of each of the notifications creating the national awards. Fundamental rights are available against the state action. Equally, it is also important to note that certain fundamental rights are available not only against the state, but also directed against the private individuals. Say for example, Article 15 Clause 2, equality in regards to access to the use of the places of public resort, and Article 17, Prohibition of Untouchability, Article 18 Clause 3 and 4 also, Prohibition of acceptance of foreign title are some of the examples. But even though they are available against private persons, their enforcement against the private persons would be possible only if some law is made to give effect to them and such law is violated. To mention an instance is the Protection of Civil Rights Act 1955. The prohibition of untouchability in the Constitution has been given effect to by this particular act, and this is important. Friends, thank you very much. Have a good day.